This is the judge's orientation for the Arkansas High School Mock Trial Competition. First, on behalf of the Mock Trial Subcommittee, thank you for spending part of your weekend with us. You are one of the most important parts of this competition, and we could not do this without your service. Even in the few hours that you will be spending with our students, you will be making a positive impact on their lives as they learn more about the justice system and trial procedure. Starting in 2019, we've returned to a regional competition format. Unless there is a bye in regionals, each team will compete twice, once as the prosecution or plaintiff and once as the defendant. In 2019, we have three regionals, and most competition formats we anticipate will have 3 to 4 regionals in the future. The top 12 teams statewide will compete at the state championship. That will consist of the top 2 teams from each regional, who will be guaranteed a spot, and the remaining spots will be filled with wild cards, the next highest scoring teams statewide. Those teams will compete at the state championship, and the state champion will represent Arkansas at the national championship. When it comes to the teams, you should not know which teams appear before you. They should only identify themselves by their letter or number code. You should not ask the teams where they're coming from, and they shouldn't be wearing anything to indicate where they are from. If you recognize a team, inform the coordinator immediately so that any appropriate adjustments may be made. This could be a situation where you have students that attend that school, or they are your alma mater and it's too close to when you graduated from high school, or any situation where you judging that team would ultimately be unfair. We have 2 types of judges in our competition: presiding judges and scoring judges. Presiding judges will preside over the trial, and they will also score the round. In the Arkansas competition, the presiding judge acts as a scoring judge. In the national competition, there are additional scoring judges in play so that the presiding judge does not act as a scoring judge. However, our competition is a bit different. The other judges are scoring judges who will sit in the jury box and act as a jury. You will receive a scoring rubric with your score sheet. As much as possible, please stick to the rubric. We've received complaints that we have very inconsistent scoring, and clearly we shouldn't have a situation where there is a wild variance. Understandably, there's going to be a difference of opinion, and that's why we use multiple judges. However, in order for us to have a consistent competition, we ask that you stick to the rubric provided as much as possible. You're going to be basing your score on who made the most of their side of the case, based on presentation, preparation, and clarity of thought or communication to the jury. Do not base your scoring on the merits of the case. We try our best to select cases that are even on both sides, but we may sometimes miss finding that case that has the right balance. Therefore, focus as much as possible on presentation and not the merits. Also, do not base your scoring on a competitor's appearance. We do instruct students to wear appropriate court attire, but we still ask that you not evaluate students based on any aspect of their physical appearance. The highest number of total points on the score sheet will win the ballot. While you may give students equal points on any aspect of the trial, such as the opening statement or the closing argument, the final score cannot be tied. If you end up with that result, please find a way to distinguish the 2 teams in some aspect of the trial and break that tie. A team that wins at least 2 ballots will win the round. And in the unusual event that a round is judged by only 2 judges and neither team wins both ballots, we will determine the winner by using the aggregate number of points on both ballots. And in the end, you should not reveal the winner after tallying the scores. That will take place after the competition. We have some specific issues for the presiding judge. Under Rule 5.4 of our competition, the presiding judge handles courtroom procedure. While our rules do allow for the presiding judge to question attorneys and witnesses, we ask that you do so sparingly and, if at all possible, not at all. It is certainly possible that if there is excessive questioning or any questioning by a presiding judge, this could affect the balance of the competition. And we want the students to make all of the arguments. So, while our rules do allow it, we do ask that you don't question any attorneys or witnesses more than what's necessary to keep the trial going. If there are any questions, this should not be considered in the score from any of the judges. There should be no electronic devices allowed by any of the participants unless there is a reasonable accommodation. Now, there may be an exception for timekeepers, as some timekeepers may want to use their stopwatch on their phone as a timekeeper. If the coordinator has allowed this, then you may allow students to use their cell phone as a stopwatch. Other than this, there should be no electronic devices allowed unless it's under a reasonable ADA accommodation. You may also waive ordinary decorum rules if the circumstances call for it. In other words, if someone is on crutches or has an obvious disability that makes it impossible for them to stand up, then you can waive the requirement that they have to rise to address the court. There is no appellate review in mock trial. Also, none of the following issues exist. There are no offers of proof, there is no motion to dismiss, and there are no motions for judgment for directed verdict or judgment as a matter of law. In the end, if it would be dispositive, don't grant it. We want both sides to give their full presentation in this case. You should also be aware that there is no sequestration or invoking of the rule. In other words, all witnesses should be present at all times. There is no voir dire of witnesses. There is no reading of the stipulations into the record, because the stipulations are already considered part of the record. There is no reading of the indictment in a criminal case, and there is no reading of the jury charge. However, students may use the jury instructions as they see fit in their closing argument. There may be an occasion where it would be appropriate for an attorney to request a bench conference if it's something that you would not ordinarily want the jury to hear. The presiding judge has the discretion to grant a bench conference. However, for the benefit of all spectators and scoring judges, any bench conference should be handled from counsel table. That way, everyone can hear all of the arguments that are presented at the bench conference. In addition, you may judge the students on whether it's appropriate to have called a bench conference. Hopefully, there will not be an emergency. However, if something comes up during trial, a presiding judge can declare an emergency and adjourn the trial for a short period to address it. During the period of the emergency, try to keep the teams in place if at all possible. Further, there should be no communication between teams and spectators and coaches. If teams cannot be held in place, then please make all reasonable safeguards under the circumstances. An example of such a safeguard would be to expressly instruct the teams that they shouldn't discuss the trial during the period of the emergency. Each team should have a timekeeper. If one team does not have a timekeeper, they may still compete in the competition. However, that team must defer to the other team's timekeeper. In the event that neither team has a timekeeper, please contact the coordinator as soon as possible to make appropriate arrangements. Timekeepers are to remain impartial, and they may only communicate the time remaining to their teams. There should be no other communication. The timekeepers should compare their notes at the end of each period. If there is more than a 15-second discrepancy between the timekeepers should bring this to your attention. The presiding judge must resolve it. The presiding judge may also provide a brief extension to allow a party to finish a remark. However, if a party runs out of time and continues without permission, they do so at their own peril. And you may take that into consideration when scoring their part of the presentation. When it comes to the witnesses, our rules provide that all witnesses are gender neutral. This means that males or females may portray any person in the trial. Witnesses cannot use notes on the witness stand, and they are bound by their own statement. Now, even though they are bound by their own statement, they are not bound by any other witness statement. And witnesses may be impeached with a witness statement as though the witness statement was a deposition transcript. In mock trial, we have a special objection known as an unfair extrapolation. Because the students are given a specific set of facts, it is certainly possible that they may be asked a question that is that is about information outside of their statement, but it's something that someone in their position would be expected to know. An extrapolation is a statement that is beyond a witness statement or the scope of the facts. A fair extrapolation, or one that we would expect our students to make, is one that is neutral. If a witness is asked about facts not in the statement, he or she must answer consistent with the statement, and he or she cannot materially affect the witness's testimony or any substantive issue. If they go too far, then an unfair extrapolation objection may be called. And the possible rulings are that no extrapolation has occurred because the information is in the statement, that the extrapolation was fair, that an unfair extrapolation had occurred, or you can take the objection under advisement. In any event, the presiding judge's ruling on an unfair extrapolation is final. There could be a dispute as it relates to the rules of mock trial. And so we have a dispute resolution procedure and process. It could be a dispute over something that happened outside of the bar or a dispute that happened over something inside of the bar. For conduct that is outside of the bar, complaints are handled by the mock trial coordinator. All you have to do is direct their teacher coach to fill out an appropriate form. For conduct that is inside the bar, however, the complaint can only be raised during the round and can be only raised by the participants. You'll receive any form that is necessary to resolve the dispute. Most trials do not have a dispute. However, we do have a procedure for resolving disputes. Don't worry, we're not going to go over this flow chart over this video, and there should be a copy of the flow chart in the materials that have been provided to you. Also, if there is a dispute and you need assistance, contact the mock trial coordinator or the coordinator who is on site, and that person will hopefully be able to help you get through the procedure for the dispute. But again, this will only be necessary if it is an inside the bar dispute, and an inside the bar dispute must be raised by the students at the end of the trial. Finally, once you have scored and you have given your ballots to the bailiff or the coordinator, the panel will have 10 minutes total to provide remarks and feedback to the students. Do try your best to keep it constructive. Also, be aware that there may be other rounds of competition, and you may be giving them advice to help them as the competition proceeds. You also have the discretion to provide the students with your contact information if you are willing to provide additional advice outside of the competition. So, once again, thank you for volunteering to judge. And if you have any questions about anything that you have seen in this orientation video, feel free to contact the mock trial coordinator or the coordinator who's on site at your regional. Thank you very much.